maybe we have, how many time we have?
20 minutes.
Okay, 20 minutes for the questions.
Thank you for all three presentations. I thought this was going to be a blue sky thinking panel, and it was a little bleak in the end, but very, very useful to understand the situation. As you can expect, I have two questions to Laurent. And the one is, well, it's more of a comment disguised as a question. So I would give a more nuanced assessment of the wonderful case law that the Court of Justice has that you listed. I think this is very much forward-looking, but you combine the Hungarian cases with the Polish cases. If you separate them, then there will be very little Hungarian cases. I know two proceedings. One is infringement, one is not even an infringement proceeding. This is a preliminary reference. The one is from 2012, the other is the IS case by Vasvári, and that's it. Now, I understand that and you hinted it at the end of your presentation that it's still nice to have these cases, for example, for a country that tries to resist a potential autocratization. Would France survive an Orbán? Which is essentially the title of your volume. But then again, in Hungary, we are in a very delicate situation now because you don't really have case law on the Hungarian judiciary. And upon the invitation of the Greens, with my Hungarian colleagues, we compiled a list of violations of judicial independence that can be either tackled or could have been tackled in the form of an infringement or a systemic infringement case, as Kim Lane-Chapelic suggested. And we have identified 30 instances of judicial independence violations, none of which have been addressed. Now, of course, you can refer to the Polish cases, but there is always a distinguishing factor. Cases are different. And now we are in a very delicate situation where, and with Matilde, we talked about this, that you have two phases for restoration. The first phase is destruction, and the second phase is rebuilding, building up better maybe than originally. But for the destruction phase, you really need to have a legal basis and underpinning. And there, EU law could have helped. And I think it's a great pity that there is no case law, unfortunately. The second is related to both your comment and John's comment in the previous panel concerning this tension between the Venice Commission and the ECHR on the one hand and the Court of Justice on the other. I think there have already been such instances, tensions between the Luxembourg and the Strasbourg court. We are always trying to reconcile it. This is what the Bosphorus presumption is there for. Now, when it comes to VC versus ECHR, to me, if I was in a leading position in a government that restores the rule of law, I would say ECHR law is binding. Period. So we take the Icelandic judge's case, we take Walesa. It's unfortunate to have a slightly opposing Venice Commission view on the matters, but then you simply go for the Strasbourg case law. I mean, we have seen member states before between a rock and a hard place, and then they always opt for the jurisdiction where they have more negative consequences in case they don't follow. So probably it's more Luxembourg than Strasbourg because you have to pay more if you break EU law than if you break the ECHR. In this case, I would simply say this is ECHR law that a democracy-minded prime minister had to follow, or parliament.
Should I answer now? Sorry.
I guess so.
Sorry, I was falling asleep on my chair. You know, it's post-lunch, like for everyone else. So I actually agree with you, unsurprisingly. Petra, it would have been much better to restore the rule of law for Hungary if we had actually direct judgment relating to Hungarian institutions. So by analogy, obviously, you can do a lot, but it would be so much easier for the new Hungarian government if there was a judgment saying that the Hungarian Constitutional Court is not a court. So yes, that being said, there is a lot which can be done by analogy, but not as easy, obviously, if you had judgments on the case of Hungary. This brings us to a different topic about what the EU could have done to better prepare the ground for restoring the rule of law, and this brings to the table actually legal aspects, but also financial aspects, and so on and so forth. But I'm not going to try to give you a summary of what the EU could have done, because it would take me a while of all the things, all the missed opportunities. When it comes to the VC, you are legally right, but politically speaking, sadly, what I'm saying is that the EU Commission is giving a lot of weight to these non-binding opinions of the VC, and these non-binding opinions may well be well-intentioned, but when they get things wrong, they produce a lot of damage in terms of helping the restoration of the rule of law. So this brings us to another debate about membership of the Venice Commission and what could be done also in terms of making sure that they have sufficient expertise to actually issue so many opinions. I think the initial mandate of the Venice Commission, or the capacity or the resource of the Venice Commission, are no longer adequate to actually help the Venice Commission answer the increasing workload they are facing. It's what I'm saying is actually something which is not positive development. The EU Commission is now subcontracting legal assessments to the Venice Commission. And if the Venice Commission is of the view that everything is okay, then this provides another excuse for the EU Commission not to actually issue or initiate legal action. And now also we are attaching financial consequences to the VC legal opinions. So if they're not complied with, regardless of whether they're actually well drafted, the EU is going to suspend or not suspend EU funding. In the case of Serbia, for instance, Serbia might lose up to €1 billion in funding, depending on whether they're going to comply with an opinion of the Venice Commission. So that's something new. So you have a non-binding opinion, which can have huge financial consequences, and this non-binding opinion is used by another organization to which is not the same as the one the expert body belongs to. So it's all very messy, I agree. That being said, what the Hungarian government could do, and sadly, you could ask the Venice Commission, but also making sure that they take into account the relevant case law. But there are no easy solutions, certainly, to answer both points in the short term.
Thanks for a great panel. I just learned a lot, actually. This question is for Anne, and you've left us with a lot of thoughts about where to go in the United States, and whether, and the United States is kind of an example of a situation that needs fixing, and some ideas about how to do that. One of which is the call that you've given out with AOC about needing to come together and building a coalition of Democrats and independents. And my question to you is, because you also pointed out that Trump has managed to keep together kind of an odd coalition, kind of Frankenstein together a number of different types of groups that you wouldn't necessarily see in a room. And my question is, does the opposing coalition need to look like the same thing? Do we need to kind of create that kind of collaboration? And really my question is, do we need someone like Trump, who would be the only type of person to bring together a group that's sort of large enough? Is the sleeping giant more like a sleeping, does the sleeping giant need someone who has a kind of charisma and authority and maybe fear creation that Trump does?
Okay, thank you for this difficult question, for which I have no answer, of course. But yes, there are lots of questions. Who should the coalition include? Whether the Democrats should stop playing by the rules? Should we have in mind somebody like Mamdani, focusing on not necessarily economic things, but how to live in New York, where to shop, public transportation, etc. Do we want, and my answer is no, as a candidate, the governor of California, who's going to be seen as the devil by half of America, and he needs to be elected. When Jean-Yves was discussing populism, of course he mentioned Bernie Sanders. I think part of the appeal has to be some kind of economic left-wing populism, but probably they tried to do it in the various elections, but it has to be more targeted, more focused, and I mean the key word right now is affordability. Apparently, the voters were not too interested in defending democracy in the 2024 election, although that was part of the message of the Democrats. So maybe they should forget about defending democracy. That's terrible, but focusing on some of the institutional reforms that I mentioned. And I think going after immunity of the president and going after corruption, to me, could be appealing themes for the campaign. With the difficulty is how do we go after Trump now that he has immunity? And we've seen that he can pardon his cronies. So how do we go after the people that obeyed his orders and violated the rules, violated the rule of law? So it's going to difficult. My concern is that there are lots of problems and very little time. And we've seen that the voters, and it's true everywhere in France, in the US, they want results immediately. And unfortunately, when there are such violations, and there's so everywhere, the results cannot come immediately. So I guess my question is, how do we buy time? How do we convince the voters that we have a good program, but we need time? Please give us some time. How to buy time? That's really what I was thinking about when I was writing the presentation. Thank you.
Thank you for your presentation. So I have, I think, one question for Deysine and two questions for Olivier Alexandre. Basically, drawing on your presentation, and I wanted to ask if, in your opinion, there was a valuable parallel or comparison that could be made between what is happening currently in the US, the attacks on the rule of law, on the lawyers, etc., and what happens during the Reagan era and the first, actually, conservative revolution. Because there was so much that was written by a critical legal scholar, in the legal doctrine about the illiberal or unconstitutional turn of the Supreme Court during the Reagan era. So I was wondering if, in your opinion, there was a comparison or an equivalence between this previous shift and the current one. And for Olivier Alexandre, I think my first question will be, you mentioned the fact that often when we are trying to understand the tech rights, we are focusing too much on these courses and not enough on the actually material interest or those technology. And don't you think it's, and you drew upon the work of Fred Turner and, for example, the distinction between Californian and Texan ideology, but are those, isn't the whole libertarian Californian myth actually a problem when we try to address the incompatibility between those companies with liberal democracy? Because couldn't it be that, are those companies compatible with liberal democracies, since their very existence relies on the negation of antitrust laws that were enacted by the Reagan administration in the 80s. So isn't their material interest, their very existence, incompatible with parliamentary oversight, a democratic oversight, and therefore, is there really a big difference between Anthropic, between Google and Musk and so on? I don't know if I'm being very clear here, but my second question, if I may, was in your field work, did you, and during your interviews, did you notice the premise of what would be, the whole Groyper's like alt-right things. Like, did you notice those ideas, those discourses during your interviews, or that they weren't present at all during your interviews? Thank you.
Me first? Yes. Okay. Well, that's an excellent question. The answer is yes. Everything started just before the Reagan Revolution. When we look at the situation today, when we look at the 3 justices nominated by Trump, when we look at all the storytelling about the courts being captured by the left, in fact, this is the storytelling I do in my latest book. I explain that everything started, in fact, in 1972 with a memorandum, the Powell memo, saying, telling business, okay, you should get involved. Create PACs, political action committees, give to corporations. We have to change the story. This is also when the Heritage Foundation were created. All the think tanks that do the story building, that inserted the... you have to remember that in 1970, Nixon created the Environmental Protection Agency. And it's because of the think tanks that they started to say, no, there is no climate change, there is no responsibility of human beings, etc. So everything, and 1982, so during Reagan, with his Attorney General, Mies, this is when they, at the time he was a professor, Professor Scalia, who became Justice Scalia, created the Federalist Society. And the role of the Federalist Society was to identify young law students that were good, brilliant, and conservative, and then follow them, train them, and put them in special administration and in the courts. And in fact, the Federalist Society has been very involved and very effective in selecting people for the courts. You may not know, we know that for the 3 nominated by Trump, who are pure Federalist Society products, but the Chief Justice and Alito were selected by the Federalist Society. And at the time, not too many people realized what it meant, but it means not changing their attitude. This is the end of what we used to call the swing justices like Sandra Day O'Connor, who would vote with the conservatives, but sometimes with the liberal to save the right to an abortion, for instance, or Justice Kennedy, who also, et cetera, et cetera. Those people now, but it may change. One thing I didn't have time to mention is that when we look at the Supreme Court, who's been very conservative most of the time, except for the short period, let's say 1955, 1975, okay. Sometimes it was ahead of public opinion, sometimes it was public behind, but the idea is that after a while, the court sort of espouses a sort of average public opinion. So there is a very, very optimistic view which says that if there was a landslide in 2026, 2028, showing that, in spite of all my fears, we Americans were not extreme rightists, but there is a sort of liberal movement, the court might change some of its rulings. Now, it won't change what it has done, except that it would sort of weaken some of the worst opinions, or reverse, but I don't see the Supreme Court with the people on the court. But I'll mention something else, which I mentioned. Julien was here, and I was criticized by somebody in the audience. There is a sort of dream by some of the Democrats that just as Ruth Bader Ginsburg stayed in the court and died and gave the opportunity to Trump to nominate a 3rd justice, there is the idea that Thomas and Alito don't want to resign. And what I'm going to say is terrible, and maybe they would die during a Democratic presidency, and then a majority in the Senate would play hardball like McConnell did, and that would restore some kind of equilibrium. But to go back to your original question, it all started during that period with a lot of acceleration during the Reagan presidency, because he was able to change the storytelling. Remember, the government is not the solution, the government is the problem. So the attacks against the administrative state, it was not called that at the moment, but the attacks against the agency started then. Thank you.
Alexandre, for the last question.
Thank you so much for the question. what I wanted to say is that almost like Jean-Yves Francher said, is that in Silicon Valley you have different lineages politically. You have conservative, you have socialists, you are Republicans, but actually the technological companies and corporations have eaten democracies and these different ideological movements, meaning that they reproduce themselves as an organic core. And at the end of the day, whatever are the values inside and within the companies, a company wants the same thing. They want less and less taxes, they want more and more profits, and they want less and less political ordeal and hurdles. And actually, it's a really well organization as a sector. I mean, the competition within this sector is incredibly and far higher than in real estate, for example. But they are quite good to work together for this very short list of themes, including in European Union, actually, the most important lobby, and by far, in Europe is tech. We have more lobbyists in tech than European Parliament. So, I mean, it's something. And about the Groyper's questions, I mean, I would say that the political contract in Silicon Valley and in tech is that you can say whatever you want. And partly because there is no real, I mean, institutions, no churches, even families. It's a place where people have the less number of kids in the US, and it's a place also where people get divorced the most. I mean, there are no moralization from this point of view, and actually the fact to have a free spirit and to be able to say whatever you want is part of this place. And if we look back to how developers in the 80s and 90s speak to themselves, it was, I mean, quite violent. Mostly it was about, we would say today, a troll culture. But this culture starting to be like the pop culture. Plus, the other thing is that with tech, we have more freedom, more communication tools, of course, but we have more and more inequalities for a lot of different reasons. And it feels like the eager for more and more people to express their voice in the cyberspace, whatever the consequences are. And the final thing is that, I mean, one of the historical and political goals of Silicon Valley has been to weaken gatekeepers, and sometimes for good reasons. But doing that, we have less and less, I mean, agencies and people who are, or a political organization who can moderate the situation. And actually the position of the European Commission has been like in the bank sector to say that the main corporations have to moralize their own activities, saying that you have to take care of the moderation. But we know that we don't have access on how they moderate, and depending on the political shift and atmosphere, they tend to be more and more eager to do that well. Yeah.
Thank you so much. We have the time for last question. One more question.
Yeah, thank you. Bastien Charodeau. I mean, so the question is simple. Well, it's not simple. It's general. But I was wondering how grassroots movements fit into your prospective solutions. And the reason I'm asking this question is a lot of the social and political life happens not through the courts and not through traditional institutional processes. Two examples. So maybe this is more for Anne and Olivier, but Laurent, feel free to chime in. What has been happening in Minnesota, in LA, in terms of resisting ICE? I think I know less about this, but there's been a kind of a slowly growing grassroots movement against tech in the US, which is also kind of interesting that it's in the US that this movement is gaining strength. And And what's interesting to me in these grassroots movements, I don't know to what extent they can reach that kind of federal level in the US or have that kind of impact, but is they generally manage to act both through the law, using lawyers and courts, but also outside of the law, whether through legal means or just means that are not neither legal nor illegal. Just so, and Minnesota is an example of that. It was not just going through lawyers, but it was also helping people, hiding people, whistling when you saw ICE agents, learning what to do. All of these things are not legal, but that are part of the resisting these attacks on the rule of law. Thank you.
Okay. You mentioned federalism, and I think we have to keep in mind that federalism is one of the last checks, in fact. I mean, if we consider that the judiciary is not much of a check, Congress has disappeared for the moment, federalism plays a role. And it's true that some of the states, of course, they are the democratic, governed by the Democrat states, show the example, etc. There's the... Anyway, I think, of course, it won't be in Alabama, but we see examples of a few even Bible Belt states resisting some of the pressure of the Trump administration on gerrymandering and some of the things, etc. So we see that the resistance is winning. And I think what's important, you said it, is to realize that when there is a reform movement, it's because Congress is pushed by public opinion, is pushed by demonstration, pushed by the grassroots. So at the moment, Congress is doing nothing. But if we think of what happened after the Watergate, Congress did enact quite a few reforms that have been dismantled by Trump. But let me give maybe two examples. The law that created the inspector generals inside each administration, each agency, whose role is to point and take care of abuses, overview, and a little more than overview, and the Ethics in Government Act, also violated by Trump at his cronies, but in theory, members of the legislative branch and executive branch must disclose their possessions. There are some limits, etc. So, in fact, in my second question, when I said political process, I was thinking of Congress, because there is a lot that Congress can do, and can do not only to change the institutions. I gave two examples. Go back to what was dismantled by Trump, to the post-Watergate era, but concerning the Supreme Court, who's playing such an important role, there can be many limits on the power of the courts. Let's think about the power to choose its cases, the certiorari. The fact that the court can say, I want this case, I don't want this case, means that the court now has an agenda. I want to change the law in that field. If Congress changes the law that they voted like a century ago, telling the Supreme Court, after a lot of lobbying by the court, yes, you can select your cases, and says, no, that's finished. Now you have to take more cases that bring something. In the 1970s, the conservatives made sure to limit the powers of the court in the field of habeas corpus. Now there could be a Congress limiting the powers of the court to rule on certain subjects, maybe immigration. And there's also, lots of people are talking about that, Congress voting a law saying, if you want to rule that a law is invalid or unconstitutional, you need a 2/3 majority, or you need unanimity by the justices. That's very easy. You just need a law by Congress. So a lot of the reforms, many of them have to go through an amendment, which is complex, but lots of little things, not so little, can be done by laws voted by a different Congress, of course.
Yeah, thank you for the question. Actually, when I was doing my field work there, I was following the anti-eviction mapping project in San Francisco, and the ones that they did Google bus actions. And after a few years, all the members just disappeared of San Francisco because of the gentrification. I mean, the less and less people could afford to live in town. And we can see that this process in different places, plus tech has been really good to do what, for instance, Hollywood and the movie industry has failed to, is to break the unions and the mobilizations through different things. First, by cutting them off directly when you have like a worker organization, coalition, mobilization. From a day to another, they just cut them off. They can enter to the company, factory, or whatever. Plus, what they have done through many, many years now is relocate. For instance, we have several cases, and quite important actually, of toxic activity in the computing industry, including Apple, Fairchild, IBM in North Carolina. And actually, I mean, since the 70s or something like that, and they still try to fix the solution. And what they did at that time is that they relocate the factories, starting with less social-oriented and leftist states. And after that, they went to China for doing the same job. That said, I will also state and claim that if we look at the urban policies and plans in the different cities that I mentioned, like Cupertino, Mountain View, even San Francisco, mobilization is something that a representative take into account. And so maybe we have to stay optimistic from that point of view.